Each week, I hold one or two forums in the district on topics vital to your life. Here's another show that we tape.
Good morning, everybody. I'm Melissa Negron-Wiener. I am a partner with the elder law and estate planning firm of Genser, Dubau, Genser, and Kona. We are located on 110 in Melville. We do everything elder law and estate planning. That is all we do. I've been with the firm for 16 years and practice primarily in the elder law and area, and I do a lot of the estate planning as well, a lot of Medicaid planning, Medicaid applications. So I'm going to try to cover all of that for you today. Please ask questions as we go. I like to take questions, on the topic while we're talking about it. I think it's better for everybody that way, and I'm happy to answer any questions that you have. All right. The first thing I want to talk about that I always discuss with any seminar that I'm doing, regardless of the age of the audience or health issues of the audience, is advanced directives. That's power of attorney, healthcare proxy, and living will. So can I see a show of hands of who has those documents in place?
All of them?
Well, some of them, all of them.
How about a half of them?
Okay. All right, so what I'm going to do is go through each one. If you do have them, I'm going to tell you to pay attention to what I'm saying because I'd like you to go home and take a look at them. Make sure that they're up to date. There have been some changes pretty recently in some of the documents, so I'm going to just tell you about each one, and like I said, feel free to ask questions. So the first document's the power of attorney, and that's a document where you name someone to make financial decisions for you if you cannot handle your own finances. All right, so you're going to be naming either one person or you could name two people who will handle anything from, handling your bank account, paying your bills, writing checks, to filing tax returns for you, dealing with the IRS, dealing with Social Security, dealing with Medicare, with your insurance company. See, when you're somebody's power of attorney, you're somebody's primary contact person, or you have children who may at some point need to care for you, they have to do a lot of different things when it comes to, transferring assets perhaps, applying for Medicaid, getting information from the banks, making sure your insurance coverage is covering whatever, if you're in a facility, if you need home care. So in order for them to do that, they have to have a very good power of attorney in their hands, okay, that says that they're the appropriate person to be doing those things. Okay, now, like I said, you can name one person under a power of attorney. You can name two people. I've even had I've had clients who've named three people, all right? And you can say whether or not you want them acting separately or together. So people's initial instinct is always to say, well, they should act together. That way they know what each other is doing and whatever. We typically recommend acting separately because acting together actually means together. So if someone was going to do something as simple as, pay the water bill and send a check, both people would have to sign the check. So it can become extremely tedious. So if you're going to name more than one person on a power of attorney, it's better to name them acting separately. In a power of attorney, you can also name successor agents. So that's a backup. So if you want to name one person up front and then a backup, you can do that. Two people up front, two backups, sky's the limit, whatever you want to do, okay? The most important thing to remember, if you have a power of attorney already, or if you're going to go do one and pull it off the internet, keep in mind that a power of attorney that's a back and front sheet of paper is not a good document, okay? In 2010, the power of attorney laws changed significantly. Okay, so now the power of attorney has your general statutory powers, which is any of you that has a power of attorney probably has those powers. It's usually A through P or A through O, one page. The new document allows us, as elder law attorneys, allows us to modify all of those powers. So why would we have to do this? The banks, the government, the IRS, the Medicare, Social Security, it's not good enough for them for you to just have my agent can handle banking transactions anymore. Okay, that's not enough for them. They want to see more information on what you're allowed to do. Okay, so for example, if your power of attorney was going to go change something with your IRA for Medicaid purposes, and we'll talk more about that in a little bit, they would need to have a power of attorney that didn't just say banking transactions, because your IRA is usually not with a bank, it's with a financial institution, a brokerage house, whatever, whatever the case may be. They need to have more specific language in the power of attorney. So we modify each power that the statute gives us to make it more usable, okay? Easier for your agent to use. In addition, in the new powers of attorney, there's something called a statutory gift rider. Okay, so it used to be under powers of attorney, your agent could transfer money out of your name up to, there's an IRS limit. This year it's $14,000. It used to be 10. People kind of know the 10. Up to $14,000 per person per year. The new powers of attorney limit that number becomes $500. All right. The reason for that, and we were talking about this a little earlier outside actually, is all the fraud that goes on. Okay. So in order to protect people more, the power of attorney document only allows your agent to move $500 per person per year out of your name. Now, why would your agent need to move money out of your name? So a lot of times we'll have the adult children contact us and say, mom's in the hospital, she has to go to rehab, I need to figure out what we're going to do, how can we protect some of the assets? And, initially we may advise, okay, let's move some assets out of mom's name, maybe to a trust, maybe, whatever the plan is, they're going to have to move more than $500. So the statutory gift rider is actually a separate document that gets attached to the back of the power of attorney, where you're giving your agent not only the power to act on your behalf, but you're giving them the power to move any amount of assets out of your name. Okay, so without that document attached to the new power of attorney, we can't really do much. Our hands are tied if we're trying to do an asset protection plan. All right, so it's not as simple as printing a power of attorney off the computer or going to a stationery store and buying a power of attorney document. They're really very structured. They're very much set up for each individual person. So it's important to look at what you have and see if maybe you think it should be updated a little bit, okay? Any questions on the power of attorney? Yes.
I've noticed that most banks want you to sign their own power, their own form.
Right.
Because it's being done in a local branch, and they're told that their form is good.
Right.
They're not lawyers. They don't know if your form is good, so they don't want to accept your form.
Right.
Number two, if they do take your form, then there's going to be a delay because they're going to have to send it to their legal department to get verification that it is good.
Yes.
So, in your experience, what problems have you run into with banks?
Okay, did everybody hear that? Okay, so basically the issue with the banks is legally they must accept a validly executed power of attorney. Okay, we actually put a letter attached to the front of our powers of attorney, a letter to the bank that says, pursuant to such and such statute, you must accept the power of attorney. They're not allowed to require their own if you have one, although in some cases I have said to clients, you know what? You still have capacity. You can still sign the document. Just sign it. It's the path of least resistance. It doesn't mean that yours isn't good anymore. Okay, but when this becomes an issue is when the parent has become incapacitated and cannot sign the bank form. All right? And in those cases, we've had to deal with the legal department at banks. But as time goes on, it's become more and more comfortable for them. They know what the forms look like. They know what to look for. They know, what the document needs to say for it to be valid. So it's becoming less of an issue in my experience, but we typically will help our clients deal with that and make sure that we do it quickly. Any other questions on the power of attorney? Yes?
If someone has an old form, do you recommend that they fill out a new one?
Yeah, so the power of attorneys changed in 2010. If you signed a power of attorney before the new forms came out, it's still valid, all right? If you signed an old form after the new ones came out, it's actually invalid, completely invalid. If you have a form that you signed before 2010, I absolutely recommend updating it only because even though it's valid, it doesn't have all of the things in it that it should, okay? Anything else on the power of attorney?
I just came in late. Can you just tell me, prior to that you said, that you have to have a power of attorney legally? It's not, you can't just use a form, you were saying something?
Well, what I was saying was that the forms that they have on the internet, the forms that they have in stationery stores typically aren't good forms. You know, if you want to, you really do need to make sure that you have everything in there that you need. The purpose of these documents is so that someone can take care of you if you become incapacitated. So you want to make sure that you have all the language in there that needs to be in there. You want to make sure it's executed properly. You want to make sure that there's no questions. And the forms that you can get, you know, like I said, from stationery stores, they're not always the right forms.
Where you get the right?
So, at an attorney's office, yeah. Okay, so moving on to the healthcare proxy. Healthcare proxy is a document that names someone to make healthcare decisions for you. All right, so this is a little bit different than the way the power of attorney works because the power of attorney, once you sign it, it's effective. The healthcare proxy is a little different. You sign it, but as long as you are able to communicate your wishes to your doctors, they are going to listen to you. So your healthcare agent under the healthcare proxy is only going to become involved in decision making if you can no longer communicate what it is that you want. Okay, and this is in New York State, this is any and all healthcare decisions. So it could be anything from a simple procedure to end of life decisions that your agent would be making on your behalf. In New York State, you can only have one agent at a time. Unlike the power of attorney where you can have two, you can have three, you can separately, together. In New York State, one at a time. So if you have a healthcare proxy, and I cannot tell you how many times I see this, go home and look at it. If it says I name my son John or my daughter Mary, it is no good. Okay, because that's two people. The or does not work, or an and does not work. It has to be I name my son John. If he's unavailable, unable, or unwilling, I name my daughter Mary. Yes?
How about if you have a trust? You have two trustees. Aren't they both supposed to be on the healthcare proxy?
The trustees under a trust and the agents under a healthcare proxy have nothing to do with each other. They don't have to be the same people. They don't have to be the same order. Nothing. Your trustees under your trust are more similar to your powers of attorney than they are to your healthcare decisions. Okay? Yes?
On that health proxy, when you said if the person you name becomes unable to perform his duties, do you put that down on the health proxy, then so-and-so will take over?
Yeah, so the question is, do you put on the healthcare proxy who takes over?
Right.
And the answer is yes. In most cases, people will put one healthcare agent and a backup. In some cases, I have people, for example, a married couple that has 3 children. The married couple, they'll put husband and wife will put each other first, and then they'll put all 3 children. But each time it says, if the above is unwilling, unable, or unavailable, then this person each time, okay? Another thing you can put on your healthcare proxy is whether or not you want to be an organ donor. Okay, so do you want to be an organ donor? I've had people say they want to be, but not for medical research. I've had people say they want to be, but only if it's for one of their family members. So you have the ability to make that decision as well in your healthcare proxy. All right, the healthcare proxy does need to be witnessed. We do notarize it. So again, these are documents that somebody is going to need to use to make a decision for you. That could be something as important, obviously, as an end-of-life decision. You want to make sure it's executed properly. It has everything that it needs to have.
I don't think it's required to be notarized, though, is it?
No, but we notarize them.
Just need the witness.
Right.
So it doesn't have to
They don't have to be notarized by statute. They do not have to be notarized. They have to be witnessed. Okay. In addition, and this goes for anyone who has a healthcare proxy, go home and look at it. See if it has HIPAA language in it. Is everybody, I should say, familiar with HIPAA? You know what HIPAA is? It's a Privacy Act. So when you go to the doctor, you know how they make you sign 1 million forms about where they can leave a message, who they can talk to, what they can say? That's HIPAA, okay? And the language for HIPAA basically says that according to this Privacy Act, your agent is able to get medical records. It's all about medical records, okay? So if the language isn't in your healthcare proxy, your agent may not be able to get medical records. Now, if your doctor's office, your regular doctor's office already has this person written down, then sure, they'll be able to get records from your doctor. But if you're in a hospital situation or something else, a specialist that doesn't have this person in your file, they're not going to be able to get medical records if the HIPAA language is not in the document. So you should definitely go home and read what you have and see if the language regarding HIPAA, regarding the Privacy Act, is in there. Yes?
What does HIPAA mean?
It is the Health Insurance Privacy and Portability Act, I believe. It's HIPPA, I think. HIPAA. I always mess that up. It's the Privacy Act. What? 2 P's? 2 P's. Yes. Thank you.
On the appointment of agent and alternate, is there a time frames involved here? Let me give you an example of what I mean. I appoint you as primary. I appoint this gentleman as alternate. When you're needed, you're on a trip to Europe. He takes over. You come back from Europe. Do you then take over?
Okay, so
Because you might disagree with him.
no. So I understand and appreciate what you're asking, but the bottom line is if your healthcare agent is overseas somewhere, most likely they are still reachable. So whether it's by email, text, telephone, there has to be an attempt made to contact the agent, okay? Typically, the agent's going to be a child, typically, or a spouse. So there's going to be some, way of communicating that's probably already been fleshed out if you have a family member that's away, okay? But if it's determined that they are unreachable, okay, and that a decision has to be made, they're unavailable, they're done. That's it. They're off, and the next person comes up. So they come back, they're not an agent anymore.
So decisions can, decisions that a hospital, for instance, may require an agent's signature for, can be done over the phone?
Absolutely. Everything can be done over the internet, over the phone these days. You don't have to be physically present.
I
Yes.
have 2 questions. If the witness predeceases you, that has signed your healthcare proxy, do you have to have it done over again?
If the witness predeceases you, no. The question is if the witness passes away, do you have to have it done again? Usually you don't even know the witness, typically. I mean, if you were to come to our office, it would be our paralegals witnessing the document. So it wouldn't require you to have to redo anything at all.
Okay, the other question is, if you come into the hospital and you need life support, and you signed a do not resuscitate order, how long will they wait before they get you the documents to show them that do not put her on or him on life support? They won't wait that long.
Okay, so the question is, if you go into the hospital and you need life support and you signed a do not resuscitate order, how long will they wait?
To keep you from putting you on life support.
Well, okay.
You signed this in your healthcare proxy. I do not want.
Okay, you got a couple different things going on. First of all, the I do not want artificial resuscitation, nutrition, hydration is not supposed to be in your healthcare proxy. It's actually supposed to be in the next document that I was going to discuss, which is the living will. 2 separate documents, okay? So in New York State, your healthcare proxy should say, I want this person as my agent, and this person is my backup, and here's the Privacy Act, you know, they're allowed to get medical records, and I don't want to be an organ donor, and that's it. You know, my agent knows my wishes, that's okay, but my wishes are not to be resuscitated, not to have this, not to have that. That does not go in your healthcare proxy. That goes in your living will as a separate document. Now, let me finish answering this one question. No, that's okay. I don't want you to forget though, so write it down. Okay. A do not resuscitate. A do not resuscitate order is a completely separate animal. So you go into the hospital for a procedure. They ask you if you want a do not resuscitate order, which means if you go into cardiac arrest, you don't want to be resuscitated, right? So you sign that, you have your procedure. If everything goes well, you leave the hospital, that do not resuscitate order goes in the garbage, okay? It does not stay in your hospital record for the next time you come in. The next time you come in, they will ask you to sign another one, all right? So your do not resuscitate is only for if I go into cardiac arrest, don't do anything. So that's it. That's 1, 2, 3. They won't do anything. When you're dealing with putting somebody on life support, the question is more going to be, it's going to be put to the healthcare agent, because most likely you're not going to be able to communicate at that point in time whether or not you want it. So it's the agent that's going to make that determination based on what they know. And what they know is what you put into your living will, because that's your instruction. That's your instruction to your agent.
You have to put it in, or could you leave it not in and just let?
You can let them make the decision, but it certainly takes the burden off of them to have your wishes written down in black and white. Did I answer your question?
Not exactly, because your living will usually isn't with you, you don't carry it,
Right.
You have it at home, or you've given it to your agent.
You've given it to your agent, right? So it's your agent that's going to be telling the doctors.
Emergency, you're into the hospital, and they want to put you on some life support.
And they can't get your agent on the phone.
And once they're on, it's hard to get off.
That's right, but they will put it on. Doctors take an oath. They have a right to, they have an obligation to keep us alive.
Yes.
They are going to put you on life support.
And getting you off, because you do want to be on it, is a bear.
We've done many court cases with getting life support either removed or put back on.
So do you carry this living will with you all the time?
No, you don't need to carry it with you, because they're not going to look for it, and they're not going to see a piece of paper and just go by what it says. For them, they're going to err on the side of caution always to protect themselves, protect the hospital, and they're going to put you on life support. Okay? Now, there are living wills that you put on your refrigerator. So this is kind of a new thing where if an EMT comes into the home, once they step over the threshold, they're required to do whatever they can to keep you alive. Okay? But they do go, a lot of them are trained to go to the refrigerator if you have not a living will, but a do not resuscitate order on the refrigerator. So that's something else worth looking into. We don't give them out. Sorry. Right. So there's a lot of, there's a lot of moving parts to this, and it's not easy decisions. It's not easy, it's not easy for the agent either. But we try to make it as appropriate as possible, pursuant to the statute, to make sure that if that time does come where someone has to make a decision, they can make a decision, because you want the person you choose making that decision. Yes?
You mentioned that the healthcare proxy form, like, is expired, you do one for this happen, always going down the line. You're
Well,
saying that with
You mean the power of attorney?
and
Yeah.
the healthcare.
So, no, I mean, the bottom line is this. I can't tell you whether or not your power of attorney, your healthcare proxy, or your living will are good documents without looking at them. So if I have somebody come into my office and I look at their documents and I see that they were done by an elder law attorney that I know, and I see that they were executed correctly, fine, those are good. All right, but most often, more likely, you're going to come in with a document that I'm going to look at and say, this isn't good. This doesn't have everything that you need, and we'll go over, what we can do, and it'll be up to you.
Forms themselves expire, even like
No, the forms will only expire if the laws change. Okay.
$10 a day.
Right. Right. Did you?
I just wanted to go back to the HPPA.
HIPAA. Yes.
That's the Privacy Act?
Yes.
Now, we get that from the doctor's office, we have to get it? and
No.
attach it?
The language should be in your healthcare proxy. It should be part of your healthcare proxy. The doctor may have you sign HIPAA forms, that they keep in their
Right,
records.
right.
But your healthcare proxy that you sign
Yeah.
should have the language in it for HIPAA.
Oh,
It's
that
not
comes- That comes in the document?
Correct.
Oh, it's already stated,
right.
that's part of the form,
Right.
okay, thank you.
You're welcome. Okay, so any other questions on the healthcare proxy? All right, so we basically went over the living will, but I'll just kind of reiterate. The living will in New York State is not a controlling document, okay? The living will is instruction to your agent. So in New York State, as of right now, your agent is a decision maker. All right, living wills are really, really important, even though they're not statutory and they're not the deciding document. Because we've seen cases where there's an agent, okay, say the daughter, and she says, I know my mom didn't want XYZ, whatever, artificial nutrition, hydration. I know she didn't want any of that. And then sister number 2 comes out of the woodwork saying, but wait, when mom's sister passed away, they did do this and that, and I know that's what she wanted. Now you have 2 people. You have one person who's the agent, who should be the person they're listening to, and one person who's making a lot of noise. The doctors are kind of like not sure what to do. That living will, that evidence of your wishes, is going to make a big difference in a case like that. All right? So, although it's not a statutory document, it's an important document. Okay, any other questions on those 3? All right, the only other thing I'm going to tell you is this. If you have children, you have grandchildren, anybody 18 and over should have these documents. These documents have nothing to do with age, they have nothing to do with health, nothing. Once you are 18, your parents no longer have the ability to make decisions for you. So we're actually, in our office, we're having a 2-month program in January and in December and January. Every Wednesday, we're going to be available for college students to come in and do their powers of attorney and their healthcare proxies, because it's so important. People go away to college, something happens, they get taken to the hospital, the parents are on the other side of the country, they're paying all the bills, and they can't get any information until they're in the actual vicinity, in the hospital, and if the child is able to give permission, then they can talk to the parents. But if the child is unconscious, the parents cannot get any information just because they're the parents. So just a little extra thing to keep in mind if you have children, grandchildren in that age.
You're in the hospital, and let's say your brother or your sister come in, the doctor won't tell them what's wrong with you?
If you're in the hospital and your brother and sister walk in, nobody has healthcare proxy, you can't give the doctor permission to speak with them. They will be reluctant to speak with them. I won't tell you that in practice they don't, because I've been in that situation myself, where I've been the daughter going into the hospital and, oh, you're the daughter? Okay, this is what's going on. In practice, okay? But you don't want to be in a situation where you get that doctor that won't, all right, or that nurse that won't, or, right. All right, so those 3 documents, yes.
On this HIPAA type of thing, what's the situation where a child is under 26 on their parents' medical? Does the parent have the HIPAA right? Or is it
No.
just, as long as they're 18,
18.
whether they insure them or not, the child has to have his own paperwork?
Doesn't matter. You insure them, you pay for their car, you pay for their college, you pay for their books. Can you tell I have a kid? Yeah. You pay for everything. 18, that's it. No information. My kid's not 18, by the way. So, again, those 3 documents are super important for everybody. Bottom line, all right? So now I want to talk a little bit about Medicaid, because that's usually what people want to hear about, okay? And asset protection and how to basically put things in place. So anybody in here have a trust? No, you said you do, right? No? Oh, I thought you did.
Division, but not.
Oh, okay, all right. So for Medicaid purposes, there are two types of Medicaid, all right? There's community Medicaid and institutional Medicaid. Community Medicaid is if you're home and you need assistance with some of your activities of daily living, bathing, dressing, grooming, using the bathroom. If you need some assistance and you want to stay in your home, but you want some help, okay, that's community Medicaid. Institutional Medicaid is if you need to be in a nursing home, okay? So two different kinds of Medicaid, two different kinds of applications, two different sets of rules, all right? So I'm going to start with community Medicaid. Community Medicaid does not have a 5-year look back. Is everybody familiar with the 5-year? Everybody's heard of the 5-year look back? Okay. So one of the biggest pieces of misinformation out there is that the 5-year look back pertains to community Medicaid. All right? It does not. If you need help at home and you want Medicaid to pay, you can transfer all of your assets today and on the first day of November be eligible for community Medicaid. Okay? The 5-year look back does not exist for community Medicaid. They do look at 3 months of bank records. But even if the month before, like I said, today, you transferred $300,000 out of your name, November 1st, you are financially eligible for community Medicaid. Okay? Medicaid says you cannot have more than $14,850 in assets. Okay? But this does not include retirement money. So again, if you have somebody who transfers money, brings their account down to $10,000, but has an IRA with $200,000, they can still qualify for community Medicaid. All right? We're talking checking, savings, money markets, bonds, brokerage accounts, anything that's not qualified retirement money, that counts. Okay? IRAs, 401ks, 403bs, those don't count. All right? Everybody with me? Okay.
You said retirement?
Retirement accounts don't count.
Don't count.
Don't count towards that $14,850.
Two questions. That you own a house, that doesn't count either.
So the house is tricky. You can qualify for Medicaid with a house in your name, but they will put a lien on it for whatever they pay out. So we also want to move that house, all right? And we're going to talk about that a little bit too. And
Second question, what about income? Pension?
yep, I'm going to get to that in just a second. Any other questions on the asset amounts? Yes.
So the qualifications for the 3 months look back for community, the qualifiers the same as the 5-year look back for institutional, or are there a couple of differences?
There's no real issue no matter what you've done in those last 3 months. They don't care. They just want to see the last 3 months of statements. It's just part of their review. So again, you give $300,000 away and you need institutional Medicaid, you have a problem. All right? But for community Medicaid, it's a non-issue. It's no problem. All right? Okay. So now, this thing is so cold, but it feels good, but it doesn't. I know. My hair feels like it's blowing. Okay, so now we have $10,000 in our checking account. We're financially eligible. Now we have to look at income. Now this is for home care. Remember, we're talking about community Medicaid. Medicaid says that you cannot make more than $825 in income. That's pension, Social Security, IRA minimum distribution, divided by 12 because you take it once a year, and any interest that you might be getting if you have an irrevocable trust or something like that. So all of that, yes, is income. And Medicaid says you can't make more than $825 a month. A month, yeah. So everybody, pretty much, who I see, makes more than $825 a month. Okay, so what are we going to do? What used to happen is Medicaid would say, okay, let's say you make $1,825 a month. Medicaid's going to say, take $1,000, pay the home health aides, and we'll pick up the difference, and you keep your $825. And with that $825, you pay for your food, you pay for your bills, you pay for your taxes, you pay for your rent, whatever you have. Obviously, this wasn't working, and what was starting to happen, people were applying for food stamps, people were applying for HEAP to keep their heat on, so it was costing the government more money. So we kind of backed up a little bit, and now what they let us do is something called a pooled income trust. Anybody familiar with that terminology? All right, it's a little convoluted. In the blue folder that I gave you, there's a book, a guidebook. There's information in there about the pooled income trust. Basically what it is, it's a special trust that's set up through a not-for-profit that takes care of people with disabilities. And that pooled income trust is there so that $1,000 that if somebody's making $1,825 a month in income, instead of that $1,000 going to the home health aides, that $1,000 goes to the pooled income trust. And then the pooled income trust will use your money to pay your rent, your taxes, your electric bill. So it's like an administrative middleman that's going to make sure that all of your bills get paid with your money, but it's a legitimate spend down for Medicaid purposes. Okay, so if you have more than $825 in income, Medicaid says you have to spend down, that's the terminology, your excess income. So by spending down, you can either give the money to the home care agency, which we don't want to do, or you can give the money to a pooled trust and then send them your bills and they will pay the bills from your money.
What if you don't have enough money from the 820? Let's say you only have $1,000.
Well, if you don't have enough money with the pooled income trust, it means that you didn't have enough money before, because you are paying a very small administrative fee, but you're not really losing very much money in income. So the idea is to give you the ability to access all of your monthly income. All right? So the pooled income trust is a great tool. Everybody always says, what's the catch? As far as I'm concerned, the only catch is if your income builds up in that pooled trust. All right, so let's say you make $2,825 a month. So now we're putting $2,000 into the trust and you don't use it all every month. It can build up. Now, some people, they own their home. I tell them, let it build up and then pay your property taxes with it. But let's say it builds up a little bit and you pass away. Whatever's left in that trust will go to the not-for-profit as a donation, okay? So that's what people think is the catch. I don't really see it as a catch because it enables you to have use of your income while Medicaid is paying for your home health aid, which could cost you $7,000, $8,000 a month if you needed 24/7 care. So I think it's kind of a give and take, unless you have an exorbitant amount of income, in which case we might not even do a pooled trust. We might just figure out a way for you to pay privately for the care. So everybody's case is different. We come up with all sorts of creative plans, but I just want you to have the general information regarding the Medicaid rules, because a lot of people, they kind of think in their head like, oh, I'll never qualify for Medicaid, and then just forget about it. But it's very easy to qualify for community Medicaid. Okay, you just have to move things around. If you want Medicaid 24/7, it's not up to you, it's not up to me, it's up to the agency that comes in and does the assessment. All right, so once we get the financials in place, we get the assets below the $14,850, we get the income set up with the pooled income trust, then the agency's gonna come in and they're gonna do an assessment at home to determine how many hours Medicaid's gonna pay for. Yes?
Is it an irrevocable trust?
It is a pooled income trust. It is irrevocable. However, you can stop funding it, okay? And the money can be used to pay any of your bills, but you can't just go in and pull the money out. Okay, so in that sense, it's irrevocable. Yes.
Can you carry that money over from year to year?
Yes, the money will carry over as long as you're alive. It can keep carrying over. Yeah, you had a question?
I just want to know, this is done by the lawyers that you've hired, this whole,
Yes.
pool thing.
Yeah, I mean, you can set up your own pooled income trust. I don't think you need to have an attorney, but it is really complicated.
Yeah.
So I usually will tell people it's
I'm just curious to
yeah.
know where the money, where it's held and who.
right. So the question is, where's the money held? What are they doing with it? Well, they put it into an interest-bearing account, and it's in a pool of money with, if all of you were on community Medicaid, all of your money would be in the same pool. All right? That's how they do it. And yeah.
Where does that money go after you're deceased?
If there's money left over in your little pot, it will go to the not-for-profit as a donation.
Not-for-profit, that's what I'm trying to.
Well, you can choose. There's a lot of different ones, but they're all not-for-profits that help people with disabilities. There's one called Life's Work. I don't know if anyone remembers Life's Work. That's the one that Geraldo Rivera made famous back in the day when they closed yeah. There's another one called Life Inc. There's a ton of them, and they're all pretty much the same in that their main purpose is to help people who have disabilities.
Foundation.
The what?
The Clinton Foundation.
Yeah,
Can
no.
you go there?
No.
If you make, for example, $1,800 a month Social Security, can you, without doing a pooled trust, can you just show that you have expenses and show that you pay rent
No.
and food to bring it down to $825?
No.
Without the pooled trust?
No. The only acceptable spend down, remember that word, the spend down from Medicaid, is to either pay for the home health aides or put it in a pooled trust. They won't accept
don't
anything
count-
else.
Oh, no, they don't count expenses?
No. The only expense they will,
Medical expense, no? If you're paying.
well, Medicaid would be paying your medical
You
expense.
don't have it yet.
Yeah,
Once you get it. you have it.
right. And the other thing was, I lost my train of thought. I lost what I was going to say. What'd you say right before
Well, they
that?
don't count your bills and rent?
No, the only bill they will allow you to deduct is your health insurance premium. So if you make $1,800 a month and you pay $200 health insurance, your $1,800 becomes $1,600, so your overage is only up to the $1,600. So they do allow that deduction, yes.
You're allowed to put that money into a pre-burial fund.
So you can prepay funeral arrangements for Medicaid purposes, but not with excess income. You're going to do that with your assets. So when we're in the process of helping somebody bring their assets down to the allowable level, we may suggest going and setting up a prepaid funeral arrangement, which is a legitimate expense for Medicaid purposes. Yes.
What happens if they're your husband and wife,
Mm-hmm.
and you each have income, some income coming in? How do they work that as far as bills on the taxes on the house, which is in both your names? Deduct only half of them then?
Good question. So the question is, if you're a husband and wife and one of you is on Medicaid and the house is in both of your names, how do they allow for the taxes to be paid from a pooled income trust? If do they do half or? So the real easy answer is, if you were a married couple and you're going on Medicaid, I'm not going to let the house be in your name because we don't want them to put a lien on the house. So we're going to move the house into your husband's name
Before you go
anyway.
on Medicaid, you have to do that before you go on Medicaid?
Yes, I would recommend it. Yes, yes.
Is that part of what the community?
No. I'm going to talk about the institutional and just one more question on this. Go ahead.
Yeah, I got a little trouble following the money. Of the example you gave for the $1,825 income,
Yes.
1,000 goes into the pool trust.
Right.
Pool trust pays your bill.
Right.
Medicaid pays your
Home care.
home care.
Hmm.
What about the 825?
The 825 you keep. So you may need it to pay some of your other bills. Like we'll usually sit down with our clients and say, all right, let's see your monthly expenses. And then we'll say, all right, have this one, this, and this paid by the pooled income trust, and have this paid by, like, for example, you get your lawn taken care of, right? So the pooled income trust can't pay the lawn company because usually they just want cash, right? You just pay them cash usually, or whatever it is, or someone who comes and does a quick thing around the house. The pooled income trust pays a bill. They won't reimburse, okay? So that is something that the 825 would be used for, because that you keep and you can use for whatever you want. So we sit with our clients and we go through their monthly expenses to try to help them determine, what makes sense to come from where. And then once it's in place, it works like a well-oiled machine, okay? Yeah.
That 825 that you're talking about, is that put in a separate account or is that also in the pool?
No, the 825 can just go into the regular checking account. Yeah. What's going to happen is the income is going to come in just as it always does. So if the income is directly deposited into a checking account, it's all going to come there, and then your amount that you have to give the pooled income trust is going to stay the same every month, and every month is just going to be a check out to the pooled income trust, and the rest will stay in there. Yeah.
If you have 24-hour aides in the home, if you go to this, you keep the same aides?
Good question. If you have 24/7 aides in the home and you're paying them privately, and you want to switch to Medicaid, can you keep those aides? The only way you can keep those aides is if they're with an agency that accepts Medicaid. If they're not with an agency that accepts Medicaid and they're legally in the country and they're certified, okay, then they can sign up to work for the agency, in which case they will probably make less money than they're making now. So you may end up giving them a little extra money to bring them up to where, whatever they were making now. So there's ways to do it depending on their status, their situation.
If you're on medication, but you don't need an aid, you still have to get professional.
If you're on Medicaid and you don't need an aid, so you're just using Medicaid as health insurance,
If you need Medicaid, like actually help with something, like you go to the hospital.
okay, so if Medicaid is your health insurance, like through the marketplace, that's not what that's not what this is. Okay, this is,
Get off your house.
right, this is the home care and this is the institutional. So let me just jump to the institutional because we're like almost out of time already. So the institutional is a whole different animal, all right? We've already said the community Medicaid, you can move money, no problems, no issues. The institutional Medicaid is completely different. You still have to get your assets down below the 14,850, and they still don't look at your retirement money and all of that. But anything that you give away, they're going to penalize you for. All right, so let's just first get out of the way. If you're a married couple, you can transfer assets between each other, and there's no penalties for Medicaid purposes. So husband and wife, one of them needs to go to a nursing home, we transfer everything to the other one, and that one that needs to go to the nursing home can get on right away on Medicaid. No penalties, no problems, no issues, unless they've given money away to somebody else during the past 5 years. So spousal transfers are exempt. Other exempt transfers are transfers to disabled children. Now, you have to be very careful with this, because if you have a child that's disabled and that child is also receiving government benefits, you don't want to put money in their name and screw up all of their benefits. So it's not something that we typically do or recommend. Once in a while, we'll have a situation where we have an adult child who might be on disability because they hurt their back at work or something. They're not on any sort of government benefit. Then maybe we'll use that exclusion, but very rarely. The other exempt transfer is a caretaker child exemption. Okay, and that has to do with only the house. So if you're living in the house and you're a single person and your child is living with you for at least 2 years, prior to your entrance into the nursing home, you can give the house to that child, and only that child, without any Medicaid penalty whatsoever. Okay? So those are kind of your exemptions under the Medicaid program. Yes?
For example, if you transfer the money to a disabled child,
Mm-hmm.
does it have to be 5 years before you apply?
It doesn't.
Doesn't.
But you have to be very careful with that, with the transfers to a disabled child. Okay? All right, so now we know husband and wife, we can always get the first one on. So let's say we have a husband and wife and we transfer $300,000 from the wife to the husband. The wife goes into the nursing home, she's on Medicaid. She passes away, and now the husband gets sick, goes to the hospital, needs to go to rehab, and is still sitting with the $300,000. All right? So now the initial reaction I get usually from the adult children, who are the ones that will contact me, is what am I going to do now? There's all this money. We're going to have to spend it all on the care. Does anybody know the cost of a nursing home on Long Island?
About 90,000 a year.
Wow, you guys are
15,000 a month?
Thank you. 15 to 18,000 a month. Okay? So it's a lot of money. So that money's going to go very quickly that you worked your entire life to save, right? So what I'd like people to know and to take away from these seminars is there's never going to be a time where you have to spend every penny. All right? We can always protect half of the money. So if there's a married couple, we can protect all of it. If it's a single individual, we can protect half of it. All right, and we do that by using something called a promissory note. It's a complicated calculation. It has to do with moving assets to children, okay, which we only do in this case. We don't recommend really ever otherwise. But moving assets to children and having children pay back some of the money to pay for the care while protecting the other half. But you don't need to know the math behind it. You just need to know that there's always a way to protect half. I've had so many people come to me saying, you know, mom's in a nursing home. She's been there for, 3 years. We spent all the money down. We need to apply for Medicaid. Where I know that had they come to me 3 years ago, I could have protected half of the money. But they don't know. And they go to the nursing homes, and the nursing homes say, here, pay us privately, and then, we'll apply for Medicaid. So it's really, really important to know that. But more important than that is planning ahead. So you're all sitting here. You all came here today. Does everybody in this room, raise your hand if you own a house? Okay. So for most people on Long Island, largest asset, right, is the house. And, I can't stress enough that if you can move that house out of your name and start the 5-year clock for Medicaid, for nursing home Medicaid, there's a 5-year look back. If you can start that 5-year clock, that's going to be the best way to protect as much as you can. If you plan ahead and you get through those 5 years, we can protect everything, okay? But so people, I know from dealing with my clients, people are very, very comfortable and happy knowing that they can protect the home. Okay, so how do we do that? We do it by putting the home into an irrevocable trust. Okay, that's why I asked if anybody had a trust. So you all have a home and none of you had a trust. So that's very, very, very unnerving to me. So I want you to listen to what I'm saying, okay? We set up an irrevocable trust, all right? Maybe your kids are your trustees. We sit down, we talk about it. Who's going to be the trustees, okay? Then we take the deed to the house and we transfer the ownership from you to the trust. On that day that you sign that deed, that is day one. That's when your 5-year clock starts to run. So 5 years down the road, should you need Medicaid or 10 years or whatever it is, that house is completely protected. Okay? So, a couple of little nuances. We give you what's called the equivalent of a life estate. All right? A life estate means you have the right to live in the house as long as you're alive. You keep all of your tax exemptions. So if you're getting a star, a senior, an enhanced senior, a veteran's exemption, you keep them all. All right? And you have complete responsibility and control of that house. Okay? Your kids cannot sell it out from under you. Nobody can kick you out of it. You have the complete protection in the home. Okay? Now, that being said, let's say 3 years down the road, you call me up and you say, Melissa, I think we're going to move. I think we want to go to Florida. Okay? All right. So the trust can sell the house. Okay? I always tell people to think of the trust as another kid that can't get in any trouble. Right? We don't want to give it to the kid. We want to give it to the trust. That is for the kid later, all right? But we don't want to put it in the kid's name now because it can cause all sorts of other problems. So it's in the trust and we want to sell it. So the seller in the real property closing is going to be the trust. The buyer down in Florida, guess who it's going to be? going to be the trust. Okay, so the trust is going to sell property. The trust can buy property. Your 5-year clock never stops running. Okay, day one, it starts to run. You sell that property, you buy something else, doesn't matter. It never stops running. Okay, what's the downside? People always want to know right away, what's the downside? So let's say we have a house and we sell it. We sell it for $400,000 and that money has to stay in the trust. Okay, now we don't want to buy something else. We want to rent. Well, I can't get my $400,000. That's what people get concerned about. It is an irrevocable trust. So technically, you do not have the ability to access that money. Okay? You have a right to income from the trust, which is interest and dividends, which we all know is not all that much these days. But you would have a right to that income, but you couldn't just go into the bank and withdraw principal. But as long as your trust is created properly, your trustees, your children, most likely, do have the right to transfer money out of the trust to your beneficiaries, presumably the same children, right? So they can move money out to themselves, to their sister, brother, and that money could be then used for something that you might need, okay? So there is a way to get at that money, depending on your age, depending on your situation. We may not tell you to put all of your assets into a trust. We may say, let's just put the house in and keep the other money out. So everybody's case is completely different. But I can tell you that 100% of the time when I meet with people who are in their 50s or 60s or 70s, we are putting houses into trust. It is the only planning tool we have left, okay, unless you have a caretaker child, like I mentioned before, to protect the house, but you have to do it early enough so that 5 years comes and goes without a problem. All right, so that's like the most important thing to take away from this, is to try to protect the house. And it's a very, very standard procedure. We do it all the time. Yes?
You have to own the house to rent it out of the state. What if the bank owns it?
That's okay. You can transfer, if you have a properly created grantor trust, you can transfer a home that has a mortgage on it. Okay, as long as that mortgage continues to be paid, there's not going to be any issue. You still have a life estate in your portion, in your equity of the property. Yes?
Long-term care policy, how does that fit into all this?
Great question. Okay, long-term care insurance. Who's got it? Okay. Long-term care insurance is tough these days to get. And if you have it already, it's going to depend on your policy. So if you have a policy that's a lifetime policy that's going to cover the full cost of a nursing home, that's awesome. Most people don't have that. Most people will have policies that will cover the majority of a home care situation or an assisted living. But once the nursing home comes into play, if you have a policy that pays $300 a day and the nursing home is $600 a day, you're going to want Medicaid to make up that difference instead of having to do it out of your own pocket. So you would still want to do planning to protect that in case of. All right? Yes.
Now, you're giving a 5-year span for this,
I am.
but I do not anticipate a 5-year on my life, truthfully. So the truth of the matter is it wise to even think of putting the house up onto this?
Okay.
5 years?
So when you put the house into an irrevocable trust, you're also putting in there who you want to get your property when you pass away. So yeah, I do trusts all the time where maybe somebody needs a nursing home before the 5 years and we have to backpedal. Or somebody passes away within the 5 years. Then the property just goes out to the beneficiaries. But I also have had many, many people who say exactly what you're saying to me, and then they come back to see me when they're 102. And I'm not even joking.
Pretty close, but no matter.
No, come on.
No.
Yeah.
When you put the house into the irrevocable trust, does the house go into the trust at the original purchase price of the house, like from 40 years ago?
Good
Or does it
questions.
get-
Very good question. Very good question. So, depending on the type of trust, I'm going to talk about my trust. We do grantor trusts in my office. I'm sorry, I keep hitting the microphone with my hand. Sorry, talk with my hands. No, I'm apologizing to the man who's videotaping. Okay, so when the house goes into the trust, okay, the house is still your tax property. It's still your cost basis, whatever you bought the house for, okay? But it gets the exclusion just like you would. The $250,000 exclusion on capital gains, the trust is still going to get that exclusion. So you're not hurting anybody by putting it into the trust. You're not causing any more of a tax problem than if you sold it yourself, okay? If you put the house in the trust, does it have to be updated? There is no updates that need to be made to a trust. So a lot of people will ask me that when we do trusts, like what's the annual cost of you having a trust? There's no fee no annual fee associated with having an irrevocable trust. Okay, some people file trust tax returns, but we set up our trust so that whatever's in your trust gets reported on your individual tax return. You had a question?
Yeah, what happens if you have the 5-year look back, you have the trust, one of the spouses dies before the 5 years are up?
That's not a problem. So we set up our trust so that if it's a married couple and we're doing, say, the Smith family trust, if one spouse passes away, everything just stays intact for the second spouse. The 5 years is still going, yeah. Mm-hmm. Yes. One more time. I can't hear you very well.
Can you just will
Oh,
a house to your child?
of course you can. You can. Oh, she asked, can you just will your house? And absolutely, you could set up a will with leaving all of your assets to your children. What I'm talking about is if in between now and that point in time you need care, that care could cost you everything that you have. So the thought is try to protect it so you can pass it to your children.
You can will your house you can will your house to the child while it's in the trust?
No, the trust is actually going to leave it to, if it's in a trust, the trust is going to leave it to your child. If you don't put it in a trust, then you're going to leave it according to your will. Okay? Yeah.
Can you change the person that one irrevocable trust? Can you change the person designated?
Yes. So even though the trust is irrevocable, you can change your beneficiary anytime you want by writing a new will. Because we actually draft our documents so that you can say, it's called a limited power of appointment. What it means is you can change your beneficiary anytime you want by coming to me and saying, Melissa, so-and-so's not cooperating, I want him out. We do a new will. The new will says, I know my trust leaves everything to this one and this one, but I've changed my mind and now it's going to this one. Okay? And you can do that as many times as you want. Yeah.
I had a friend that she had no living relatives, and she left her house to this girl that took care of her and in the will. And then when she was supposed to get the house upon the will, and she passed away, Nassau County wouldn't give her the house unless they did a search, a major search to find out if this woman did have any living relatives, meaning that she would have never got the house if she did have a living relative.
That's right.
And so why is it, do you need a will if they're not going to give it to the person that you designated?
Well, okay, so did everybody hear that? Okay. No? Okay. So just real quick, she's saying that somebody that she knows left a house to a person who took care of her because she had no living relatives. Okay? So she left the will, left everything, left the house to this person who took care of her. When she died, Nassau County came in and said, we're not giving you the house until we do a search to make sure there's no family. That's pretty standard. So the bottom line is this.
Let's say there was a living relative that you didn't want to give your house
Right.
to,
So let me.
the county would still give it to them?
Right. So what happens is that if you pass away and you probate your will, people are entitled to notice. Okay? Who's entitled to notice? Anyone who has standing to receive under your will. your children, grandchildren, and if you don't have children or grandchildren, a cousin, somebody has to be served notification that you've passed away, okay? So they have to do what's called due diligence, okay? They have to do a search to say, is there anybody that we need to notice? We need to say, hey, your, great Aunt Tessie passed away. Are you consenting to, us being the executor? They're not consenting to the person getting the house, but they have to consent to the probate even going forward. If they want to contest, they can come in and say, hey, that's my house. And, and we have a will that says it isn't. So probably the woman who's taking care of her is going to win. All right. But they do have that right for family members to come in and, try to get whatever there is. Yeah.
For your irrevocable trust, you're only talking about moving the deed for the house, but aren't there a lot of other assets and savings you have to
Yes.
move?
So the question is, right. So the question is, for an irrevocable trust, we're just talking about the house, but what about other monies? So first of all, you're never going to put retirement money into a trust. That's always going to stay out. But if you have other monies, like a brokerage account, some sort of, investment account that's sitting outside the trust, we may make a recommendation when we meet for you to put some or all of that account into the trust. You have to remember that once your cash is in the trust, you no longer have ready access to it. So
Then how do you get down to that amount?
in some cases, we'll have people, so here's the thing. You don't need to be down below $14,850 for 5 years. You only need to be down below $14,850 when it's time to apply for Medicaid. So I can leave you with $60,000 in your name to supplement your income over the next however many years unless, if you need a nursing home. And if at that point you still have 30,000, well, you're allowed to have 14, right? So you're 15 over. And that's when we maybe set up the pre-planned funeral, or we do something with that $15,000. So it's a really, you have to sit and look at everything, look at monthly expenses, what you need, what you have, what you can put into the trust that you're not going to need most likely. So it's a whole, yeah, whole ball game. All right, so you all have the blue folders. My card is inside. My name is Melissa. My phone number's on there. You can call me anytime you have a question. Just let me know where we met, and I'll be happy to answer any questions for you. Yes?
How about fees?
Really? We had to do this? No. They're getting up and leaving. No. Okay, so the fees. Fees. Fees are going to be different depending on what we're doing, okay? There is a consultation fee in our office. It is $500. It gets credited towards your work, okay? And the reason for that is if you come in and we sit down for 2 hours and you decide not to go forward, it covers our time, okay? If you call me 6 months later and say, remember me? I came in for a consultation. We want to go forward. It goes towards the work, all right? The fees as far as the work goes is really going to depend on what we're doing, okay? So it's something I can give you a much better idea of when we sit down, okay?